What are the standard assurances, and how does the Office for Civil Rights enforce civil rights laws? This training video has two parts. The first part will address the standard assurances that recipients sign as a condition for receiving federal financial assistance as they pertain to civil rights obligations. The second part will discuss the ways in which the Office for Civil Rights enforces the federal civil rights laws that apply to recipients of Justice Department funding. In a training video that also appears online, we previously discussed all of the statutes and regulations that apply to recipients of federal financial assistance from the Justice Department. If you are not familiar with these laws, you may want to view that training video first before proceeding. In applying for financial assistance from the Justice Department, a responsible official representing an applicant organization must sign standard assurances. The implementing regulations of Title VI, for example, require applicants to certify written assurances as part of the application packet. The assurances contain the contract provisions that every applicant must accept as a condition for receiving federal assistance. Although the exact form of the standard assurances may vary from one program office to another in the Justice Department, all contain provisions stating that recipients of financial assistance must comply with certain civil rights requirements. For example, the standard assurances at the Office of Justice Programs include the following language. The applicant also specifically assures and certifies that it will comply and will require any subgrantees or contractors to comply with any applicable statutorily imposed non-discrimination requirements. The standard assurances then include a list of all the applicable civil rights laws that we have previously discussed. By signing the standard assurances, which are a form of a contract, a recipient acknowledges and accepts responsibility for complying with the civil rights obligations that come with federal financial assistance. The Office for Civil Rights is responsible for ensuring that recipients of financial assistance from the Justice Department are complying with the applicable federal civil rights laws. But how does the office enforce the laws? The Office for Civil Rights has 5 methods of enforcement. First, providing technical assistance to recipients and subrecipients. Second, investigating administrative complaints of discrimination. Third, conducting compliance reviews. Fourth, reviewing adverse findings of discrimination against a recipient. And fifth, reviewing equal employment opportunity plans. The Office for Civil Rights is committed to providing technical assistance to recipients so that they can take proactive steps to comply with their civil rights obligations. The office believes that prevention, rather than policing, is often the most effective way to safeguard the rights of both the employees and beneficiaries of federally assisted programs. This online training video is an example of the technical assistance the Office for Civil Rights offers to recipients. The Office for Civil Rights is also available to provide technical assistance by telephone or through on-site training programs. The Office for Civil Rights accepts and investigates administrative complaints not only from the employees and beneficiaries of recipients, but also from the employees and beneficiaries of subrecipients of Justice Department financial assistance. Many employees of state and local governments that receive Justice Department funding may not be aware that in addition to other civil rights laws that protect them, the Justice Department's funding of their employer gives them the right to file an administrative complaint directly with the Office for Civil Rights. Employees of recipients and subrecipients do not have to exhaust their employer's internal remedies to file a claim with the Justice Department, nor do they have to wait for clearance from the Equal Employment Opportunity Commission or an equivalent state agency before filing a complaint with the Office for Civil Rights. Aggrieved parties do not need to retain a lawyer to file an administrative complaint. They can simply go to the website of the Office for Civil Rights, download the appropriate forms, sign them, and send them to the Office for Civil Rights. The forms are available on the office's website. When the Office for Civil Rights receives an administrative complaint, it completes a preliminary review to make sure that the allegations involve a civil rights matter over which it has authority. If it does, the Office for Civil Rights will initiate an investigation. often gathering additional data from both the complainant and the funded agency that is the target of the complaint. Once the Office for Civil Rights gathers sufficient information, it will then evaluate the merits of the complaint. If the Office for Civil Rights finds that the facts do not support the claim, it will close the complaint, advising the complainant in writing that he or she might be able to pursue remedies either in federal or state court or with other federal or state administrative agencies. If the Office for Civil Rights finds that the facts do support a finding that a funded organization is not in compliance with federal civil rights laws, the office will work with the recipient to explore ways in which it can come into voluntary compliance. The office puts a great deal of effort into negotiating resolution agreements with recipients to remedy civil rights problems, to ensure that federal funding continues. If the Office for Civil Rights cannot ensure the compliance of a recipient with the applicable civil rights laws, the recipient then risks the suspension or termination of federal funding. Here are a few examples of the administrative complaints that the Office for Civil Rights accepts and investigates. Prisoners alleging that correctional facilities discriminate against them by denying opportunities to practice their religion. Female law enforcement officers alleging sexual harassment in the workplace. Community residents alleging that local law enforcement agencies make unlawful traffic stops based on race, ethnicity, or sex. Survivors of domestic violence from immigrant communities alleging that funded service providers do not provide adequate language assistance services. And deaf or hard of hearing inmates alleging that a state prison system did not make a reasonable modification to its policies to allow them to participate in programming. The Office for Civil Rights does not just respond to the allegations contained in administrative complaints. The office also has the authority to initiate its own investigations of recipients and subrecipients through compliance reviews. A compliance review is a civil rights audit. The scope of the review can be wide-ranging, such as examining all of the employment practices of a funded program, or it can be narrowly tailored, such as inspecting the physical accessibility at a funded facility to determine whether it complies with federal disability standards. By law, the Office for Civil Rights cannot randomly select facilities for compliance reviews. The selection process relies on predetermined criteria. For example, under the Safe Streets Act, the Office for Civil Rights bases its selection of a recipient for a compliance review on regulatory criteria, which include the size of the award made to the recipient, the relative disparity between women and minorities in its workforce in comparison to the relevant labor market, and the complaints of discrimination that the office receives against a recipient. As with administrative complaints, the Office for Civil Rights gathers information from the recipient that is the target of the investigation to determine whether it is in compliance with federal civil rights laws. At the end of the investigation, the office issues a compliance review report. If the office finds that the recipient is in compliance, the report makes this finding. The compliance review report typically includes recommendations for improvement. If the office finds that the recipient is not in compliance with the law, the office works with the recipient to correct the deficiencies. The office often undertakes monitoring of the recipient for an extended period of time to ensure that the recipient is making the necessary changes. Although it is rare, if a recipient refuses to work with the Office for Civil Rights to address a finding of noncompliance, the recipient risks the suspension or termination of federal financial assistance. In recent years, the Office for Civil Rights has conducted compliance reviews of law enforcement agencies to determine whether they are providing appropriate language access services to their limited English proficient, or LEP, populations. The Office for Civil Rights has conducted compliance reviews of state administering agencies to determine whether they have mechanisms to monitor the civil rights compliance of their subrecipients. The Office for Civil Rights has conducted compliance reviews of funded faith-based organizations to determine whether state administering agencies treated them equitably in the state funding process and whether the funded faith-based organizations are inappropriately using federal resources for explicitly religious activities. Beginning in fiscal year 2011, the Office for Civil Rights has begun posting all final compliance review reports on its website. As we noted in a previous online training video, recipients of funding under the Safe Streets Act have an obligation to send to the Office for Civil Rights all adverse findings of discrimination based on race, color, national origin, sex, and religion that are the result of a due process hearing in a federal or state court or a federal or state administrative agency. When the Office for Civil Rights receives these findings, it reviews them to see whether they may indicate a pattern that may warrant the Office's particular attention. For example, if the Office receives multiple sexual harassment findings against a recipient, the information may prompt the Office to initiate a compliance review of the recipient's employment practices. Finally, as we have mentioned in other training videos, certain recipients of funding subject to the Safe Streets Act must comply with the federal regulations on developing, maintaining, and submitting to the Office for Civil Rights an Equal Employment Opportunity Plan, or EEOP short form. When the Office for Civil Rights receives an EEOP short form, it not only reviews the plan to see whether it sufficiently addresses the regulatory reporting requirements, but it also looks at the workforce data to determine whether there is statistical evidence indicating significant underutilization of women or minorities in particular job categories. If a recipient's EEOP short form raises questions about whether all qualified applicants or employees have equal employment opportunities, the Office may use the EEOP short form as the basis for initiating a compliance review that focuses on a recipient's employment practices. If you have questions about the standard assurances or the enforcement responsibilities of the Office for Civil Rights, you may write to the Office for Civil Rights, Office of Justice Programs, U.S. Department of Justice, 810 7th Street Northwest, Washington, D.C., 20531. You may contact the office by telephone at 202-307-0690, by TTY at 202-307-2027, or by email at askocr@ojp.usdoj.gov. You may visit the office's website at www.ojp.usdoj.gov/OCR.